The decision to divorce is difficult. The decision to choose how to divorce is entirely another problem that could be supremely important. When divorce is imminent, why do we instinctively draw swords to do battle with one another? Must we be enemies while attempting to find our resolve? There are alternatives. Today's program on FIT TV, with my guest Sandra Radna, is family law attorney, will discuss the choices and the subsequent issues that follow these choices. My biggest concern for families within the process of divorce is the ensuing unnecessary battle that often exacerbates the dysfunction of the family as a whole. And that's what I'd like you to comment on first before we get this program started.
A lot of times when people go to divorce, they think it's just going to be a fight. And in the beginning, if they're very angry at their spouse, they want to fight. They want to fight through their attorney, and they want to see if they can get a reaction. But the reality is that fighting is often very costly, and the person that ends up paying is not your spouse, but probably your children, if you have children, and all the savings that you had for your children and everything else, because the attorneys are going to get paid, and you're not necessarily going to get the result that you thought you were going to get, or the satisfaction that you thought you were going to get. The best way to have a successful divorce is, at the outset, to have a plan for what your goal is. What is it that you want? Who's going to keep the house? What are your plans for how the children are going to be taken care of? Who are the children going to live with? How are you going to pay for things for the children? How are you going to pay for expenses going forward? Those are the important things. How are you going to divide up the marital assets?
So you're basically saying organize your life more or less to get yourself ready for a split.
Absolutely. The most smooth divorces are people that planned ahead of time. So there's often times where you felt like you're not happy in the marriage, or for whatever reason you feel that it's not going to work and you need to split. If you go by a knee-jerk reaction just out of anger, it's going to be difficult. If you make a plan, if you say, here's what I want, and get to a point of indifference instead of just anger, then you can probably get through it much more smoothly with the focus on the children, and hopefully not having your children be victims who are just for the rest of their lives affected by what happened.
What I noticed from some of the people I've seen during my mediation process is that the fevered pitch that you get to right before you make that decision is going to, the exacerbated acrimony and the regeneration of all these things that you didn't like before are now brought to the surface, and that's when the decision is made, so you're peaked.
Right.
So if I were to address or add to what you said, that planning portion you were talking about, the plan ahead, I would plan on being calm for a while before I made the final decision, because it really can affect everything after that.
I always say to my clients, there's a thin line between love and hate. You have to get to indifference. Because when you're so angry, you can't think clearly. Just think about when you're angry about something. Is that when you make your best decision?
Absolutely not.
It's not. If you can get to indifference, if you can think through what it is that you want to focus on, what you want to get out of, whether it's a certain amount of money by the end, whether it's living in the house, whether it's where the children are going to live, if you can think of what that goal is and then work backwards on how to get there, you'll probably be much more successful. Usually what people do is they're angry, and I'm going to get them because of that one thing that happened 5 years ago, and now they're going to get theirs, and you're not thinking about the consequences.
I left a toothbrush on the table, went to work. There's a few different ways that you can divorce. There's the collaborative, and there's litigation, there's collaborative, and there's mediation, and there's, I guess, arbitration. What else would there be? I don't know, but just for a quick reference point, can you kind of define some of those things? And I can.
Well, with collaborative divorce, you have two attorneys that are trained in collaborative divorces. You sign an agreement, a collaborative divorce agreement, where the parties agree that they're going to try to work this out. And if they're not able to work it out, the attorneys that were part of the collaborative process can no longer be the attorneys in the adversarial process when you have a...
They can't represent somebody after you've been in a collaboration.
Right. Right. So that's the collaborative process, which can work, but there has to be an agreement.
Is there also other parties possibly involved, right?
Absolutely.
Can be, yeah.
Can be involved.
Yeah.
But everybody has to be on the same page as far as going through a collaborative process. If you have one party that wants to do collaborative and the other party's not cooperating, it doesn't work. If you don't have that written agreement that binds you to the collaborative process, then it's really a waste of time, because the other side can do whatever they want and make it adversarial, and that defeats the whole purpose.
Yeah, that could be a problem if the attorney that you hire to be in a collaborative process was somebody that referred, and you step out of that, now you can't call on them, as you said.
That's right.
Can't go back and get them.
So you have to be careful in your choice on what you're doing, and you have to make sure that that person's actually trained as a collaborative attorney instead of someone who just said, oh, sure, yeah, we can do that. Yeah, what, collaborative? Sure, yeah, I could do that. Mediation is different. Mediation, there's one person, a mediator. It's non-adversarial, as opposed to the collaborative divorce, you each have your own attorney. They're just agreeing to try to work out an agreement. The mediator is the least adversarial process. You have one person who's neutral, and they're really just trying to help you go through the issues, identify the issues, help you to see how you can work this out together. And then once you have that plan, that mediator, if they're an attorney, can help you write up an agreement that could then be reviewed by your own separate attorneys. Or if they're not an attorney, they could do a memorandum of understanding,
right.
And then you could take that to an attorney who'll write up an agreement.
Yeah, that's
for you.
Also, if you have an attorney with you who writes up the agreement, you still need a review attorney, so an attorney would have to step out and get another attorney to review. And as a mediator, because I do a lot of mediation work, as neutral third, we just write up a memorandum and walk that through it, which is kind of like a separation agreement, if you will. It has everything
exactly. It has all the issues identified. The attorney will put it into a legal agreement, or a stipulation of settlement, or a separation agreement, whichever way they want it to go. In your true adversarial process, each party has their own attorney, and that usually starts with the service of a summons and complaint, and you're going to court.
We talked about one of the issues that could happen in collaborative divorce in terms of a negative or positive, but regarding including litigation and mediation, what do you feel would be some of the positives and negatives, just to feel the difference for people? Yeah, so people can learn what they're help them make an informed decision. I'm sorry.
I think a mediation works best when the parties say, I want to try to work this out as best as I can, but we're not really sure how to do that. But they're basically agreeable. They're on the same page as far as they want a divorce. They usually have some major issues decided, like they know who they're agreeing to have custody, and they know what they want to do with the largest marital asset, which is usually the house. And they know they have maybe some deferred compensation things they have to divide up, but they don't know how to do that. And maybe there's a couple of issues that they don't know how to decide, which is maybe the holiday schedule for the children. That works really well with mediation, because the mediator can help them go through that process. They're already both on the same page that we want to work it out, we're not sure how. Collaborative divorce is best when maybe they're not as agreeable as mediation, but they know they want to work it out, but I really don't trust to have one person. I still want to have an attorney who's going to advise me legally what needs to be done.
Or I also trust my accountant, whatever.
Right. So I want to have these trusted professionals here to help us get through it, but I really want to have my own people.
Yeah.
And that's what collaborative is. It's more adversarial than mediation with the one neutral party, but it's still, you're deciding that we're going to try to agree to everything.
I think collaborative is a great word. I
think
hope it works. I don't know much about the system.
It's a great word. It's a great word because they're supposed to be working together, and sometimes it works.
Well, you know what's funny about mediation is it is accepted in most other states, maybe half the states. Some of them have it as mandatory, permission.
Right.
I'm trying to shoot for legislation that has a peremptory position. That's one of the things I'm working on, meaning we want that first shot to mediate. Some states already have that. I think Connecticut has it, and I think Jersey has it, but I'm not sure about that. But we're surrounded by mediation-friendly states. You're a New York attorney, primarily, right?
Yes, I am a New York attorney. I don't practice anywhere else. Yeah.
We don't have mediation. It's not really friendly here. Any reason why? Do you think it'll work?
I'm not sure what the reason why is. I think that people have a choice to go to a mediator. I think a lot of people don't understand the difference between going to a mediator first or just going directly through an adversarial proceeding. I think it would be helpful if the court suggested it and had people try it first in certain cases.
Yeah, I would think.
I think to sit with a professional that helps you flesh through the different issues of the case could be helpful to the parties. I don't know how they would do it in court if you were already in court in the middle of an adversarial proceeding. Usually people are pretty angry by the time they get there.
Isn't that unfortunate?
If you get to that, but.
Can we assume that in court, if you were to litigate, you're not really in court in collaborative or mediation, that you can get a fair view of your issues? The reason why I'm saying that is some of the people that come to me through mediation have already tried litigation and dropped out of it or got out of it.
I think there's a lot of variable factors, and the most important being who you have as your attorney. You have to have an attorney that is able to direct the client into here's what the issues are, here's the reality on how that would be resolved. If you were to litigate it, here's what's likely to happen. You have to have an attorney that's listening to what your issues are instead of just doing what they do in every other case, because it's not a cookie cutter. Your issues are going to be completely different from somebody else's issues. If you happen to get lucky enough to have two attorneys that are really trying to work towards a resolution, litigation can be very successful, and you could have a settlement even though you started
Well,
in
hated
litigation.
that you used the word lucky preceding that sentence, but you know.
Doesn't always happen that way.
Yeah.
Doesn't always happen that way, but it does happen
Well,
sometimes.
it's just a pitfall of divorce in a general way. I mean, even when you come to a mediator, you might not get the mediation that you're really, I'm being fair and honest about the whole thing. It's not always.
Well, it's like everything else, you have to do your research.
Yeah, you got to do.
You have to do your research. You have to know what's going to be the best fit. And people need to understand that they have a right to tell their attorney, no, this is what I want. It's not about what the attorney wants. It's about what the client wants. A lot of times,
that's a discouraging element I hear. I'm sorry.
Yeah, the people have to know if this is what our goal was, even if the attorney's saying, no, I don't think you should do that. If this is what you wanted to do and it makes sense for your family, you can still say, no, I understand what you're saying, but this is how I want to divide it up. Yes, I do want to pay a little bit extra child support, even though statutorily I don't have to, but I want to do this for my child.
Yeah.
Yes, I do want to let my wife have the house, even though I don't have to let her and I can make her sell it right now. This is what I want to do. There are things that you can do.
I see this so often, these examples you're bringing, which concern me that even I don't have a full opportunity to do that, but some people who come to me in mediation have these extraordinarily odd, I try to keep it reasonable and fair, ways to come to a solution. And some of them will give away 20, 30, sometimes even 40, 50% of what they could have if they were litigating, because their protective attorneys would have supported them and try to come to this equal position. And the only difference in mediation is if you can find a balance of some kind that's not directly divided by equitable distribution, you can still come to a resolution.
Well, sometimes I think the most common example is when there was a business that was established during the marriage. And the one party whose business it is wants to keep that business, and they don't want their former spouse to have part of that business. So they might give them more of, say, the retirement funds, or give them the house.
I do that kind of thing all the time, right?
Because they want to keep their business intact. So that's an example of something.
Can you do that? Can you control that? I'm sorry to interrupt you, but can you control that when you're protecting your client in a litigation process? Can you? My client wants blank.
The client has to know that this is what they're entitled to. They're entitled to this percentage of all these different assets. If they want to do something that varies from that, they have the right to do it, as long as they're making a knowledgeable decision, a knowing decision, as long as they're fully informed of what they're entitled to, and they're agreeing to waive that, then of course you can do it. They just, as long as they know. They can't make that decision and say, wait, later on, I had no idea I was entitled
Sandra,
to get
people
these
do
other
that
things.
to me all the time. They say that, I really didn't know all the things I could have known. I'm wondering if you came across that, where maybe they said, well, why didn't you tell me blank?
That's why you have to put things in writing. That's why when an attorney does a stipulation of settlement, if they are waiving, for example, the business, it'll state the reasons why, that I understand that I'm entitled to these things and I'm waiving that right in consideration of the other things that I'm getting.
It seems like in this process, it's hard for a family to identify whether they're going to go forward in contact with their children. These are some of the, remember, as an advocate, I'm hearing this all the time. And people who are inside court, while they're in court, I even court watch for people and watch other attorneys deal with what they have to deal with, and judges. And there's a frustration that develops with all these families that they're not able to keep the contact they want. And not, court ordered every other week and every other weekend and 3 days a week and that kind of thing sometimes doesn't work. There's decisions I've seen that this couple wouldn't work out that way no matter how you tried it. People end up with bad decisions. I'm wondering how much control you have in these situations.
There's not a lot of control. The way that I try to control it is that usually when you can't have an agreement, come to an agreement as far as the amount of time that both parents are seeing the children, it's usually you'll have an attorney for the child appointed, which is what we call law guardians now. They're called attorney for the children.
Attorney for the child.
And the attorney for the child is just an advocate for the child. And it's up to the attorney for the different parents, especially the parent that feels like they're being slighted, to point out why it's in the best interest of the child to have an equal amount of access with both parents. As long as there's no issues of abuse or safety, both parents should have equal access to the children. And of course, both parents have to have the time for that. You could have a situation when one parent, because of their work schedule, simply can't have the child for an equal amount of time because they're not there.
I mean, some things you see them trying to get access when the judge has decided, somehow the judge decided for an access period that was not attainable by that party. They just weren't able to get to that point, yet that's the access plan that was passed. Hard for me to imagine that they would let that go like that.
That's where the attorney comes in. The attorney has to be going through with their client. If you have the child for this amount of time, who's going to be taking care of them if you're at work?
Yeah.
Is it fair for the child to be a
stuff like
babysitter,
that.
be with a babysitter instead of with your former spouse, with their parent? And you have to go through that. It's what you present to the judge, what the attorney presents to the judge. And there's no guarantees. You could be the greatest attorney in the world and you can get a judge that's not going to do what you want to do.
It's just not connected, right.
If there's a basis in law for why you didn't, that supports that you should have gotten relief that you did not get, the remedy is to appeal it. And that's what your attorney should be doing for you. And
the appeal process is difficult, it's laborious, and it's not really overturned too often.
Yes and no. Because if you need some type of immediate relief, you can make a motion pending the outcome of the appeal. So you get immediate relief. If you have, for example, one parent that wants to take a child out of the country, and you're not agreeing to that, and you have a judge that decides, I'm going to let parent take that child out of the country. Well, what does your attorney have to do? They have to make move for an appeal immediately, but also make a motion pending that appeal. So while you're waiting for that decision, that child's not taken out of the country. Well, that you're going to get immediately if you could establish.
So you're going to have that particular portion of what your request is.
Which is the most important thing.
Right, which of course.
Right, you're going to protect the child, whatever that thing is. It could be a parent moving back into the house that you think is abusive.
It's the right thing to do. The appeal process is tough. My experience with, I've gone to the appeal process several times. I even tried it myself. Very difficult, very laborious process, and it can be time consuming. I'm going to throw out a few different things to you, like supervised visitation is an issue. How would you address that reaction to the family that's in that situation? Because it's a tough one.
There's certain situations when supervised visitation is warranted. Maybe a parent's is abusing alcohol or drugs or something that's made it not safe for the child. Sometimes the parent just hasn't been in the child's life for a long time, and then now they want to come back in. Well, it makes more sense for the child to be introduced to that parent slowly, either through therapeutic visitation, so that parent learns how to parent again, or supervised visitation. Supervised visitation shouldn't be permanent unless there's a real serious issue of abuse. If there was, say, for example, drug abuse or alcohol abuse, once that parent passes certain criteria set forth usually by the court, it's usually rehab, testing clean for a certain amount of time, that parent will end up having unsupervised visitation. But for the safety of the child, I think supervised visitation makes a lot of sense in certain situations.
I always question the rationale for getting to that point, because we've seen, of course, again, the problem I have is that I'm getting a lot of phone calls from people who have been trapped into that. And when you hear somebody on the phone, how can I be positive that everything that they said was the truth? Well, so I'm colored by that, and I do get plenty of those calls, but yeah, I'm colored by that.
Supervised visitation, I don't think is given lightly. Usually there's reasons why. They don't just give supervised visitation on someone's word. The most common reason is for a drug or alcohol problem, which they're tested right in court to see if they're testing positive for any type of substances. And usually that's the first reason. If there's an allegation of abuse, there has to be some type of proof, which is usually a court-ordered investigation that CPS conducts, and they're going to do it.
That was my next question, CPS. Have you had any situations where you could call upon the CPS as doing well and not doing well? You know, what kind of experiences have you had so far?
I think it's run the gamut. It depends on who you get as your caseworker. It depends on how thoroughly they're going to investigate the claims. I have had situations where there's been no basis for a finding of, when CPS does something, it's either going to be indicated or unfounded. There's been no finding for indicated, and the person has been unfounded. So that's good. They've had to go through the whole process, but it was unfounded. I've had situations where a client felt that there was serious abuse that was going on, and they also found it unfounded. So it goes both ways. I think that eventually, if you have enough information, it's important for clients to document things. They can't just make allegations that are unsupported by corroborating proof. It's just like anything else. You have to prove what you're saying. It can't just be that parent yelled at child or just what child said. It has to be something that goes along with it.
Yeah.
And usually if you have enough proof, you can show what's going on, and if it's necessary to protect the child will be protected, and Child Protective Services will bring their own neglect petition if they see enough there.
You briefly started talking about the alienation thing at the backside of what you just said. That's a big problem for the people that call me. They're having some experience that, oh, my ex did blank and my ex did blank, and now that I can't do this, and now I'm in the court, and the alienation is occurring. There's not a lot of recognition by the system, by the legal system.
It's very slow in coming. Alienation is a huge issue. One parent will badmouth the other parent to the child. I think and the child will usually come back to parent and say, Mommy said that you did something. I think it's important for the parent to address it right then.
My
and to
experience,
say, not say that mommy's not telling the truth, but say, well, don't you remember this is what really happened, so that the child can see that those things aren't true.
my experience with alienation tells me that it's there almost all the time in some form. I mean, people
Absolutely.
accidentally could be, here's your ex on the phone, that kind of thing. Here's the phone, you turn your head, you move, making the slightest little gesture, that child receiving that phone with the parent
Or we
making
don't
that
have
kind of
enough money
gesture.
to do this because daddy didn't send the money this month.
Yeah,
Or we
all
don't-
those kinds of
all
things,
those
yeah.
little
To me,
messages.
that's unfortunate, but I hear that all the time.
Yeah, yeah, it's a huge problem, and it's a difficult thing, but you have to, the parent the child is being alienated from has to work really hard to keep dispelling all of those things to show it's not true.
Are you okay by the percentages of child support? You know, the 25% for 2, and 29 for 3, and 17 for 1 kid, and vice versa, and all those numbers that they have. Are you okay by those percentages?
I think the percentages make sense. I think that the thing that's difficult is if people are getting other things taken out of their paycheck, and it's not just taxes, if they're paying union dues, if they're paying health insurance, other things, they feel like their net is much lower than what the court is basing the child support on. The court will the only thing they'll take out is FICA and state and federal income tax.
FICA's always, right?
But everything else, it's counted as part of your net income, and I think it's difficult for people if they're actually taking home less.
When
payer.
when you're in the middle of a, I guess, litigation as a family law attorney, do you find that you're able to reduce the amount of friction that your client is experiencing? Is this an easy thing for you to handle? Could you use support at times, and are you able to reach out to other people to get the support to eliminate the amount of acrimony that they may be feeling, for instance, before they walk into a litigation process?
I prepare my clients very well before we ever go into a trial or hearing. I explain the process, I let them know what to expect. They always know ahead of time, which really, everybody has a fear of the unknown. If you know what the process is, if you know what to expect, without delusions of grandeur, it does help. I speak to my clients all the time about what's going on so they feel like they're in the loop. That reduces anxiety as well. You can't reduce all the anxiety. Divorce and family court is one of the most emotional things that you can go through. Talking about the most personal things in your life, your family and your money.
Sure.
So I don't think you could completely get rid of it. If I have someone who's really in distress, I do suggest that they talk to somebody, some type of mental health professional that could help them either with anger management or with depression or whatever they're going through. That could help them. But as far as being ready for the litigation process, I think it's up to the attorney to constantly explain to the client what their expectations are, what's going to be happening, and I think knowledge is power. And when you make the client part of the process instead of just a side note in the attorney's process, it makes it a lot easier for the client to get through it.
Would you be able to consider making a suggestion that might modify your family law attorney inside the litigation process that might assist you better than the systems that are provided for you?
Something that would make the system work better,
yes,
I think?
yeah. What would you suggest?
I think that one of the things that's difficult for people, especially going into family court, you're supposed to be able to go in on your own. People who can't afford an attorney should be able to go in on their own, and it's really not a friendly system for them to do that. Even though there's forms online, there's no one really helping them. The pro se people, there's no one really helping them to get through that process. And I think that if they had volunteers that were there helping people fill out forms and do it the right way, so their orders of protection, for example, weren't getting dismissed in the case of a real abusive situation.
Weren't there pro se advocates?
There were, but I think due to budget cuts, they're not there anymore, at least not in Suffolk County. And if they're there, they're only there for a limited amount of time. They're not there every single day. So people go there, but they're really writing their own petitions, and they have someone that'll type it up before it gets handed in, or sometimes it gets handed in all handwritten.
Who were they? Were they paralegals? Who were they?
I don't know who it was before, but I think that there should be some type of volunteer process, that it was actual attorneys that maybe volunteer their time and do that, even if it was just one day every 6 months, that you had enough of people volunteered so they could help people get their petitions in the right way with the right criteria so they don't get dismissed and maybe go back into a dangerous situation.
In the suggestion mode of change, of possible good change for the system, might there be anything else? Like, for instance, I always say, or maybe you do this earlier on, I don't know, but you suggest to people what the probability of based on what you know on your intake, you take an intake form, right? And you fill that out. You got a basic idea of some things, right? You help them out early in that phase, or do you walk through an appropriate time to time strategic time to tell them? Do you have a strategy in mind? I mean, you have to have some strategy, I guess.
Well, when people first come to me, the first thing we do is go through what are your goals, what are your plans, what is it that you want, and we talk about a strategy. There should be a plan. I think another thing that would be helpful if we're talking about suggestions in the court system, I think that the judges that are in family court should have some training to know the signs of people that are really being abused.
Yeah, yes, what is
and
that?
I don't think they have any training. I don't think that the attorney for the children even have training. I've run into a number of situations where they're asking a mother that's been extremely abused by the father to go into therapy together to talk about things where the one parent is completely terrified of the other.
Those are great suggestions. Thank you very much.
Terrible.
Thank you. I tell you, this has been a fabulous show, and I think you're going to be able to help a lot of people if they have a chance to see the show. Hopefully in a couple of weeks they will. Thank you very much, Sandra Radna.
Thank you for having me.
Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. And at FIT, we know you can't get this information on your own, so we'll bring it to your TV every week, and we invite all opposing views. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.